Hi there. Welcome again to Help Solve the Case. I'm Christine, and today we are continuing our review of the Karmelo Anthony request for a new trial. There's a lot of reasons that the defense is stating, and we're going to go through them one by one. I want to first say thank you so much for being here. I love that you love what I love, and hopefully, I'm able to be informative in explaining some of the details as we think about, talk about, and ultimately decide why the parties are doing what they're doing. And then we get to see how it plays out in court. So hang on a second. Let me share the document with you, get myself all arranged here, and we will get started. Okay. So when we left off, the next section is talking about procedural background, timeliness, and jurisdiction. On June 9th, 2026, a former jury, a jury found the defendant guilty of murder, and on the same date, the court imposed sentence in open court, assessing punishment of at 35 years confinement in the Texas Department of Criminal Justice Institutional Division. On June 4th, 2026, the trial court signed the certification of the defendant's right of appeal. Okay, if you remember in the first video, they talked about, it was either first or second, they talked about the time limit to file the appeal, the changeover of the attorneys. It might have been in the last video that everything happened really quickly and they really didn't have a lot of time. Okay, so that might be what they're talking about here. So, so let me back up. Sorry for talking over myself. On June 4th, the trial court signed the certification of the defendant's right of appeal. Although that certification issued before the verdict, the judgment of conviction was rendered and sentence imposed on June 9th, 2026, and the notice of appeal followed. So I don't know if that lost them some dates or gained them some dates. We'll see. On June 10th, 2026, the defendant filed his notice of appeal, and the appeal was docketed in the Fifth Court of Appeals as cause number 05-26-00840-CR. On or about June 11th, 2026, after the verdict, the sentence, the certification of the right of appeal, and the filing of the notice of appeal, the presiding judge gave a televised interview concerning this case, which aired on WFAA-TV Channel 8. This motion is timely under Texas Rule of Appellate Procedure 21.4 subsection A, being filed within 30 days after June 9, 2026, the date sentence was imposed in open court. The court retains authority to consider and rule on this motion through the 75th day after that date. So that sounds like the court has to move pretty quickly because some of these appeals can take a long time. And a notice of appeal, if any, does not divest the court of that authority until the appellate record is filed in the Court of Appeals. And they cite State versus Moore. So somehow they're talking where there's some timeliness issue. Maybe, I don't know where they're going with this. Because sentence was imposed in open court on June 9th, 2026, the 30th day to file this motion is July 9th, 2026, and the 75th day falls on Sunday, August 23rd, 2026, subject to Texas Rule of Appellate Procedure 4.1. Defendant, I want to write that date down, August 23rd, because we want to watch for that, right? Okay. Defendant requests a hearing and ruling no later than Friday, August 21st, 2026. Okay. To avoid any dispute over Rule 21.8's deadline. Now, what I think might be is because remember, they said the certificate, the certification was signed on June 4th. And they filed the appeal on the 7th, I believe. That's when we saw the docket date. So theoretically, I think they're trying to prevent, because the sentence was on the 9th, and because anytime the dates are involved, they can hammer you on that. Okay. So I think what they're trying to do is prevent, because somebody in the clerk's office might just look at the certificate and see the date and automatically rule it out, right? Because they're not reading through all these things. I think that might be where they're going for. So they want to have a hearing on how many days before. They want to have the hearing to make sure that this doesn't happen, and nothing bad happens. Okay. And the 75th day falls on a Sunday, August 23rd, 2026, subject to Texas Rule of Appellate Procedure. Okay. So they want it on Friday, August 21st, to avoid any dispute. Defendant is presenting this motion within 10 days of filing, as Rule 21.6 requires, and contemporaneously request that the court sign the attached order on presentment and set the motion for an evidentiary hearing so that the parties may present evidence and the court may rule within the Rule 21.8 permits. Contemporaneously, that means at the same time, with this motion, defendant is filing a motion to recuse the presiding judge. Because Rule 18A of the Texas Rules of Civil Procedure governs recusal in criminal cases, they cite Arnold v. State, defendant requests that the evidentiary hearing on this motion be conducted by the judge presiding after the recusal motion has been referred and resolved in accordance with the rule. Now, I don't know, because this went to appeal, if the judge was still not supposed to say anything or it was the content of the statements. Remember, I think it was the second video or the first video I did. They outlined the statements that that he made to the media, allegedly made to the media, about, I think it was about allowing the people in the court and that sort of thing. So I'm not sure exactly what thing that they say he's violating, but they don't want that judge, right? So they don't want the judge hearing this motion for a retrial, and they want a new judge appointed, right? So they want the state to review the motion for recusal to get a new judge, and then they want the judge to have a hearing to discuss this motion. Okay. Maybe they're going to tell us here. This motion is supported by affidavit because it raises matters outside the trial record established by the attached affidavits and authenticating declarations, and it is timely filed and presented. Defendant is entitled to an evidentiary hearing, and the court would abuse its discretion in denying one. And they state Reyes versus State, Roselle versus State, Hobbs versus State. Those are case citations with previous, what they call precedent. Under these circumstances, refusal to hold a hearing would be an abuse of discretion because the motion and its supporting affidavits raise matters not determinable from the existing record that, if true, could entitle defendant to relief. And they talk about State versus Pilkington. That is especially so here, where the reporter's record has not been prepared. The official court reporter has advised counsel that no portion of the trial has yet been transcribed, and so the relevant proceedings cannot presently be reconstructed from any existing record. So what it sounds like is, typically when you file a motion, you can ask the judge to decide it just on the documents presented without hearing it, without the attorneys and everybody appearing before the judge, or to decide it just on the facts, or you can request a hearing and everybody, they present witnesses and testimony and stuff like that. Like when they go before the Supreme Court, right? The attorneys show up and they ask questions and they go back and forth, right? So I'm not the lawyer, but in my opinion, I would rather have the hearing. So they're saying here that they want the hearing, but they're also adding fuel to that fire, I guess you could say, because there is no transcript, right? So they're saying the judge alone who reviews this motion can't use the trial record because there's no reporter's record prepared and it hasn't been transcribed. So there's no way to do it. Okay, so that's why they want the hearing. Now, they're stating here the first ground for the new trial is that the trial court violated the defendant's Sixth Amendment right to a public trial by materially restricting public access to trial proceedings without the findings and alternatives required by Waller, Presley, and Stricker. And those are probably case citations. Now, I know about Sixth Amendment, but I am not well versed in the Sixth Amendment right to a public trial. And again, I'm not a lawyer, but this is interesting, right? Because as we read that portion and as we're going through, I'm covering and going through other cases, the media has stepped up with attorneys and stuff and talking about specifically the Charlie Kirk case and portions of the discovery and the evidence in the preliminary hearing not being broadcast to the public and the public's right and whatever. And in this case also, they've previously talked about how these folks tried to get in and they couldn't get in, and then the media were taken to other spots and things like that, and the fact that they didn't have an overflow room. All right, so let's see what they're going to say here. The issue here, the first ground, that's the first pillar, the first complaint or issue that they're talking about. The issue is not whether the court had authority to manage courtroom security and capacity. It did. The issue is whether, after adopting an access order that foreseeably excluded members of the public from a high-profile criminal trial, the court made the findings Waller v. Georgia, that sentence doesn't. The court made the findings Waller v. Georgia requires and considered the reasonable alternatives Presley v. Georgia demands for contemporaneous public access. Okay. Oh, okay. Sorry, I got to read it. Sometimes this legalese. So they're saying here that the issue is after the court adopted an access order that foreseeably excluded members of the public from the high-profile criminal trial, the court sounds like they cited Waller v. Georgia and Presley v. Georgia, that used those findings and asserted those findings, but it says it did not. The court's order gave the general public only a 10-minute daily initial admission window, left roughly 24 seats for public observers in a nationally watched murder trial, barred meaningful re-entry during proceedings, and provided no overflow room, no audio feed, and no video feed for those foreseeably turned away. So I'm a little confused there still. They either used Waller and Presley wrong or didn't use them, and they should have used them because that's precedent that the defense feels should have been applied properly. Okay, we'll leave that there. Once closure is shown, it cannot stand unless the record contains a Waller-compliant justification for those restrictions. The existing record contains none. So it sounds like if you're going to close the court, Waller, that precedent, sets out how you're supposed to determine that. And there's a justification for that. And so the defense is saying there is none. Nor does the danger end with this case. And I don't think they're talking about danger, like physical danger. I think that they're talking about future cases. Let's see what they're saying here. In a televised interview about a case that has drawn national attention, the court publicly defended these restrictions as the right way to conduct a high-profile trial, describing the decision to bar cameras and streaming as an easy decision and stating that it had, quote, struck that balance pretty well, end quote. So that means, like, I think they're saying that since it was so easy here in this high-profile trial, it's going to be really easy to do this in the future is where I think we're going with that. And let me just make sure. I want to make sure you guys can see this. Let me zoom in a little bit. Okay. Okay. Should a trial held behind a 10-minute entry window with no overflow room, no audio feed, and no live stream be treated as an adequate substitute for an open courtroom, the public trial guarantee of the First and Sixth Amendments would be hollowed out in practice. Like, it would gut those constitutional amendments. The restrictions here amounted to a closure of the courtroom imposed without the findings the law requires. Defendant does not contend that live streaming is constitutionally required in every case. The issue is that once physical seating was foreseeably inadequate, the court was required to consider reasonable alternatives and make Waller findings before including the public. Okay, so they're saying that they didn't apply the direction or the court's findings in that Waller case before cutting off the access. Here's another assertion. An open courtroom belongs to the people of Texas who fund and sustain it. Now that's an interesting, right? We pay in taxes and all that stuff. We pay for this. So we should have access to it, right? I think that's where they're going here. The openness of criminal trials is amongst the oldest and most settled features of Anglo-Saxon American justice. The United States Supreme Court has held that the public and the press possess a right secured by the First and 14th Amendments to attend criminal trials, and that absent an overriding interest articulated in findings, that's an important sentence, absent an overriding interest articulated in findings. I'm going to interrupt myself because the way I read that is there has to be something in a finding that you found something, not that we think. That's what I'm reading that, okay? A criminal trial must be open to the public. I could be wrong. They quote all these cases here. It says a presumption of openness, quote, inheres in the very nature of a criminal trial under our system of justice, end quote. For a public trial gives assurance that proceedings are conducted fairly, discourages perjury and misconduct, and guards against decisions based on secret bias or partiality. They quote Richmond newspapers. As the court observed, quote, it would be difficult to single out any aspect of government of higher concern and importance to the people than the manner in which criminal trials are conducted, end quote. Okay. Texas has long spoken to the same effect in its own voice. The Code of Criminal Procedure commands, quote, the proceedings and trials in all courts shall be public, end quote. Texas Code of Criminal Procedure, or I don't know what art means, 1.24. Okay, that's where it's referenced at. Okay, the Court of Criminal Appeals has embraced the presumption of openness recognized in Richmond newspapers, that's at court precedent, explaining more than a century ago that the Texas, quote, Constitution is but in accord with the genius and spirit of our free institutions, which is intended to guarantee publicity to the proceedings of our courts, end quote. And that's, they got Houston Chronicle Publication Company versus Shaver, and, you know, the subset citations there. And they say these guarantees are not abstractions. They are not held by the accused alone. The open trial guarantee belongs as well to the citizens of Texas. Now, this is interesting. It just struck me, right? So that first sentence says these guarantees are not abstractions. and they are not held by the accused alone. Now, this is Karmelo Anthony, okay? And this is the defense talking about publicity and wanting the open court. Now, what did we have what do we have in the Charlie Kirk, Tyler Robinson preliminary hearing? We have the defense continually objecting about publication and people in the courtroom, even us on the live stream, and people in the court seeing these documents. So isn't it interesting? This is what I find fascinating about the law when I talk about the Netflix show, meaning one side puts on their thing, the other side puts on their thing, like the chess game. So here, one is saying, we didn't get it, we need it, all this. And then another case, the defense is saying, no, 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 it's bad, 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 right? So again, I'm just generalizing there, right? You can go and watch the transcript or whatever. But I think that's interesting, okay? And what they're saying here, hang on one second. What they're saying here is, in this first sentence, this is not just held by the defendant. The citizens of Texas says the trial guarantee belongs as well to the citizens of Texas, in whose name the prosecution is brought, right? It's state versus. Think about that. If you never thought about it, it's state versus. That the state represents us, the people. Well, I don't live in Texas, but you know what I'm saying. Okay, the state represents all the citizens in Texas. So the open trial guarantee belongs to them, in whose name the prosecution is brought, by whose taxes the courthouse and the court are sustained, and whose confidence in the administration of justice, depends on their ability to see that justice done. Public attendance is the mechanism by which the community observes that the court it funds are functioning lawfully, a check on official power that the Supreme Court has repeatedly identified as a core purpose of the open trial guarantee. And they quote Waller v. Georgia again. When the public is excluded from a Texas courtroom without lawful justification, that injury falls on the defendant whose Sixth Amendment right is violated and on the community whose courtroom it is. It is the defendant's injury that this motion vindicates. The community's stake underscores why the violation is neither technical or trivial. So what they're saying here is that Waller, it appears, gives some instruction or some process about what, like the elements of Waller, the citation, what needs to be in the record, what the findings or whatever need to be so that it can be closed. A public trial is staged for two audiences at once. The first sits in the gallery. The citizens in whose name the case is brought, that's the state, who watch to satisfy themselves that the state proves what it claims and that the accused is not quietly condemned. The second sits on the bench and in the jury box, the judge and jurors, for whom the awareness of being watched is itself a discipline, keeping them, quote, keenly alive to a sense of their responsibility and to the importance of their functions, end quote. That's from Waller, okay? So that's a good explanation of what they're talking about and why. A 10-minute entry window empties both galleries at once. It turns the public away before it can watch, and it relieves the court of the very audience whose presence is the discipline. What the order described as access operated in practice as material exclusion. History explains why the law guards the open courtroom so jealously. In the public trial guarantee is a long-standing safeguard against secret proceedings. In re Oliver, that's a citation, it, quote, has always been recognized as a safeguard against any attempt to employ our courts as instruments of persecution, end quote. What openness protects, secrecy endangers. A proceeding the public cannot watch is one in which the ordinary checks on error, overreach, and bias quietly fall away. That is the structural risk a closed courtroom creates, whether or not anyone can later prove the harm the secrecy concealed, which is precisely why the law treats the deprivation as structural, okay, like foundational, and does not put the defendant to proof of a hidden injury. So what they're saying there is it's foundational. It's not, there's not a response, like it's structural at its core, like it's there, and it's not that the defendant has the burden of proof after the fact or whatever. It is there. It belongs there. Okay, that's what I think they're saying there. A courtroom may be closed only rarely and only on the showing Waller requires. The most directly applicable appellate authority, say that 5 times fast, on this precise question is a published decision of this Court of Appeals handed down months before this trial began. So now they're talking about Texas, that there was a decision months before the trial. So, we're not going back to the Constitution necessarily. They've got an pretty much instant case. In Stricker v. State, the Fifth Court of Appeals held that a trial court violated the defendant's Sixth Amendment right to a public trial and ordered a new trial where the court, citing courtroom space and a generalized security concern, refused to seat a single member of the public during jury selection without first considering the reasonable alternatives the law requires. Now, they're not talking about this defendant. They're talking about Stricker, whatever this case was for Stricker. And when it went up on appeal, let's go through these pieces. When it went up on appeal, they ordered a new trial because the court, this is what their argument is, the court, citing courtroom space and a generalized security concern, refused to seat a single member of the public, during jury selection. That's just jury selection. That's not the trial. They're saying they refuse to seat a single member. So I don't know how many members of the general public, like how many members of the general public does it need? Okay, it says, trying to get out of the citation here. Because Stricker was designated for publication under Texas Rule of Appellate Procedure 47.2 subsection B, it is a published memorandum opinion of this Court of Appeals, and thus the most directly applicable appellate authority on the public trial question. And having been issued months before this trial, it was available for the trial court's review when the court entered the amended order and closed these proceedings. The closure here was therefore not the resolution of an unsettled question. It ran headlong into a recent published decision of the very court that reviews this one. So what they're saying here, I think, is that, look, and we see this back and forth in the courtroom. The attorneys cite these cases and the rules, and sometimes the judge is like, I got to look this up. Let me review this. And they argue back and forth, the attorneys, their interpretation of these precedents, these citations, and the Constitution. But what the attorneys here are saying for the defense, they're saying, look, this thing just came down, and it looks like January 29th, 2026. So it came out and it was published, and the court, right, just as police officers do, attorneys, everything, you have to keep up on these Supreme Court decisions and these court decisions, especially the judiciary, right? And I don't know the rules or whatever, the Code of Judicial Conduct or whatever for the judges in Texas, but the dude, the judge, no, I shouldn't call him dude, His Honor, I think it was His Honor, they're saying should have been aware of it, and that was the most recent discussion and citation and decision about this. So he should be well aware of it. Every justification the Fifth Court rejected in Stricker is a justification the court invoked here, and that rejection was on far more extreme facts. So what they're saying that the reasons for the closure or the restriction that they cited in Stricker, the Fifth Court of Appeals said they don't count. Okay. And they're saying here that the rejection was more extreme facts, or in Stricker it was more extreme facts. So what they're saying is what happened here was specifically the things that they talked about in Stricker. So here, we're going to get into it. In Stricker, the court refused to seat one observer because the veneer filled the gallery. Here, the court rationed the general public to roughly 24 rotating seats across every stage of a nationally watched murder trial. There, in Stricker, the trial court declined to split voir dire to make room, explaining, quote, "I'm not going to spend 2 days picking a jury," end quote. The Fifth Court held that space and overcrowding, though legitimate concerns, quote, "must not outweigh a defendant's Sixth Amendment rights," end quote, because there are, quote, "readily available alternatives," end quote, and that, quote, "neither convenience nor judicial economy can constitute an overriding interest," end quote. And they're quoting this other case. Okay, so what we heard was, and I never read that order, so I'm not sure. I'm just going on what the defense has put in here. But they didn't have room and all this stuff. They only did the overflow viewing for the jury selection. And could that be why? Right? Because this Stricker case talks about jury selection. It does not talk about trial, right? From what we're hearing here. So did the judge do the jury selection overflow because of Stricker and not do the trial? I don't know. These are all good questions, right? We don't know. So it says here, in Stricker, in this case, in Anthony, the record and the court's own public statements at least raise a fact issue that reasonable alternatives existed, including larger or additional courtroom space, a live audio or video feed, and the overflow accommodations the court used during jury selection and then withdrew, right? So they're going to say, well, you did it for jury selection. Why can't you do it for the rest of it? And if you remember the statement, going back to that TV statement, the judge said, I want to thank the other judges. I think it was the TV statement. I want to thank the other judges for, juggling and moving around and doing all that stuff. So, could they have swapped courtrooms? That's a question to ask. In that courthouse, was there a bigger courtroom that they could have used? We don't know. Okay. And where the Stricker court faulted the trial judge for failing to, quote, identify a specific concrete fact, end quote, of danger, okay, it says the order here, that's in the Anthony case, rests on the same generic recital that unrestricted access, quote, may compromise, end quote, security entered without a hearing. If excluding a single member of the public from jury selection required a new trial in Stricker, then the recurring exclusion of numerous members of the public from testimony and punishment after the court withdrew an available overflow alternative and made no Waller findings cannot be dismissed as trivial. So now we have to see how the judge is going to view this. And obviously, this is why they don't want the same judge to be reviewing this for a number of reasons, right? Because they may feel that there's bias or misinterpreted Stricker. So now the question is for the attorneys, my legal minds here, because Stricker applied to jury selection only, and I would like to know Did the public get to see the jury trial in Stricker, but they didn't get to see the jury selection? Does this, because because Stricker's talking about jury selection, does it apply to the trial, right? So I don't want to say which part of it is more important, but I would think that the trial would be more important than jury selection, although if the public right is the public right, they should be equal. So that will be interesting to see how that is viewed. It also says here, a second court of appeals reached the same result weeks later on facts materially indistinguishable from the space rationale invoked here. Okay, so now maybe I get my wish and they're going to answer that right here. In Hernandez v. State, the 14th Court of Appeals reversed a capital murder conviction and ordered a new trial because the trial court closed voir dire to the defendant's family and the public, citing an 80-person veneer and a lack of, quote, physical space, end quote, without conducting a Waller analysis, making findings, or considering reasonable alternatives. Okay, so it sounds like what they're saying here, they're interpreting Hernandez to say that because an 80-person with the lack of physical space, I'm not sure, okay? It says here, the court held that concerns about space, quote, must not outweigh a defendant's Sixth Amendment rights, end quote, and admonished that, quote, trial courts are expected to know and apply, eyebrow raise, this basic rule, end quote. You guys know about my eyebrows. When they go out, it's like, whoa. So they're saying here, I mean, that's some language, right? Trial courts are expected to know and apply this basic rule, okay? And when did that one? Okay, now that one came down May 19th, 2026. So again, we talk about, I mentioned judicial responsibility, staying current. I don't know how these, and that's Texas. So they should be up on their own state. I don't know how those, come down. If they come down in email, they read them in like judge briefings, they get them mailed to them. I don't know. But, that's a strong statement. Okay. Stricker and Hernandez are thus recent published Texas decisions holding that a space-based closure of jury selection, okay, so it's jury selection, entered without Waller findings or the consideration of reasonable alternatives is structural error requiring a new trial. And both were available for this court's review before this trial. Now, it's talking about jury. It's not talking about trial. So I don't know. Stricker and Hernandez addressed the merits of a space-based closure. Dixon and the preservation authorities address when the complaint must be raised. I don't know. Did we see Dixon? I don't remember seeing Dixon. Hopefully that's not a typo. Dixon and the preservation authorities address when the complaint must be raised. Defendant satisfies both rules here because the closure was administered off the record and the as-applied exclusion became apparent only after trial. The Court of Criminal Appeals has likewise reversed on a narrower version of this problem. In Steadman v. State, the court reversed the conviction and ordered a new trial because a trial judge excluded the defendant's family from voir dire out of a generalized concern about space without articulating a specific threat and without considering reasonable alternatives. Okay, so this is another, it looks like jury. This case is Steadman magnified at every dimension. So again, I'm going to ask, is the jury selection different than the trial? What do you think? Which should have more weight? I don't know. Where is that elaborated here? I don't know. So it says this case is Steadman magnified at every dimension. The court excluded not one family, but the general public, not from voir dire alone, but from every stage of the trial. On findings no less generic that unrestricted access, quote, may compromise security, juror privacy, and a fair trial without a hearing. And after using, then abandoning the very kind of overflow alternative, Steadman faults the courts for failing to consider. So, I mean, yeah, it sounds good because, again, not that we consider jury selection less than trial, but the application of the trial process, I think would be, more of a right, equal of a right, but more of a right, if that even makes sense, to see the whole trial. Um, and he apparently, the judge apparently did it during the jury selection. So, if you can do it here, you can do it here. I don't know. Maybe he only did it because Stricker was jury selection. I don't know. We'll see what happens. Very interesting, right? To me, it is. If barring a single family from jury selection was structural error, demanding a new trial, excluding members of the public from substantial portions of jury selection, testimony, and punishment is so a fortiori. I don't know what that word is. Okay. The Sixth Amendment to the United States Constitution guarantees the accused in a criminal prosecution the right to a public trial, a guarantee applicable to the states through the 14th Amendment. In Oliver, they're citing that. The Texas Constitution independently, so aside from the U.S. Constitution, they're saying the Texas Constitution independently secures the same right, providing that the accused, quote, shall have a speedy public trial, end quote. There it is. Okay. We typically see speedy trial utilized, but there's that word in there. Like we usually focus on speedy. We don't focus on public. Okay. But there it is. And that's Texas Constitution, Article 1, looks like subsection 10. And it says, additionally, here's third, the Code of Criminal Procedure reinforces it, quote, the proceedings and trials in all courts shall be public, end quote. And that's the criminal procedure. And I know in watching the attorneys in the Charlie Kirk, Tyler Robinson preliminary hearing, they were trying to, they were quoting Constitution, state Constitution, U.S. Constitution, state, and rules, okay, and how those all jockey together and how they apply. The right to a public trial is not confined to the presentation of evidence. It extends to jury selection, Presley v. Georgia. Before a trial court may exclude the public from any part of a criminal proceeding, it must satisfy the four-part test of Lawler v. Georgia. We're learning a lot about this, aren't we? I mean, I think this is good to apply to other cases because, like, in the Charlie Kirk, Tyler Robinson preliminary hearing, the attorney from like the media kept popping up, and I was like, wow, okay, like this is weird. I don't know about all this stuff. I've never really heard all this articulated, and so I think this is very interesting for us. And we learn through all these pleadings and stuff. Before a trial court may exclude the public from any part of a criminal proceeding, okay, it must satisfy the four-part test of Lawler v. Georgia. 1, the party seeking to limit access must advance an overriding interest that is likely to be prejudiced. Oh, the interest is likely to be prejudiced. Any limitation must be no broader than necessary to protect that interest. 3, the trial court must consider reasonable alternatives to closing the proceeding. And 4, the trial court must make findings adequate to support the limitation. The Court of Criminal Appeals has adopted and applied this test. They quote Steadman v. State, Lilly v. State. The trial court bears the burden of, the trial court, that's the court, bears the burden of considering reasonable alternatives. The balance of interest, quote, must be struck with special care, end quote, and, quote, findings by the trial court are the linchpin of the Waller test, end quote. So findings, they're talking about findings, that there has to be findings, which, they haven't articulated any of that, right? They're talking about that that, remember, it's structural, it's foundational. The burden is not on the defendant. So they're saying here, what I believe is that the findings, like the court has to cite something. They just can't say we think. That's where I think they're saying there. Not sure, again, not the lawyer. The right of public access applies with particular force to the selection of the jury. Okay, maybe they're going to explain to us here. The Supreme Court has held that the guarantee of open criminal proceedings reaches the voir dire of prospective jurors because the selection of jurors, quote, has presumptively been a public process with exceptions only for good cause shown, end quote. So, sounding like the Supreme Court, right? We got the Constitution, public trial. So now the Supreme Court is backing it up a little bit to the jury selection. And they cite Crest Enterprise Co. versus Superior Court. Open jury selection was the settled practice in America when the Constitution was adopted. Okay, so it was already there. And the court emphasized that proceedings conducted in secret frustrate the very public interest that open selection exists to serve. Yes, it does, doesn't it? Yes, we know that. Closure of jury selection is therefore permissible only on the same showing of an overriding interest, narrow tailoring, and specific findings that Waller and Press Enterprise require. The order's restriction nonetheless applied to jury selection along with every other phase of the trial conducted behind the same closed doors and unsupported by any such findings. All right. So that was pretty interesting, I think, okay? More than I ever knew about the public openings. And it was interesting because me at least, reporting for you guys, are seeing this go back and forth in the Tyler Robinson, Charlie Kirk case. And I'm like, why are they arguing so much? The court in the trials that I participated in, there's never been a problem, okay? And so, I had heard some things about this case, people access, just general things, the parking lot and all that stuff. So I think this is very, very, very educational. It's very detailed. It's a lot of reading, but I think it's very informative. So I thank you for being here. I love your comments. I tried to get to all of them, and we just need to learn about this process. And again, change the laws or make the opinions or do the things right. If we have to really understand our rights and know, what we want, what we have a right to. And if we don't have a right to that, then we need to enact legislation or evoke change so that we get what we're paying for, first of all, right? So this is, I think, to me, very informative. So thank you for being here. Thank you for liking and sharing. And I will see you on the next one.